So welcome this morning to today's webinar. My name is Carly Hanson from Community Legal Centres Queensland, and this webinar is about assisting self-represented litigants in family law matters. So before we get started, I'd like to acknowledge the traditional owners of the land on which we're holding today's webinar. We're in Brisbane today, and Claire, our presenter, is also in Brisbane. So I'd like to acknowledge the Turrbal and the Yagara people here. I'd like to pay respect to their elders, past, present and future, and acknowledge the very important role that Aboriginal and Torres Strait Islanders continue to play in our society. So as this webinar is being viewed by people throughout Queensland and Australia, I'd like to also pay my respect to the traditional elders of the land throughout the country and extend a very warm welcome to any First Australians listening in today. So today we are really fortunate to have a fantastic presenter, Claire Dart. She is a barrister and nationally accredited mediator, registered family dispute resolution practitioner and arbitrator. She's been practicing in family law, child protection and domestic violence for over 20 years. So a wealth of knowledge, and it's really great that she's happy to share that with us all today. So Claire will talk in this webinar about how to assist your clients in preparing to cross-examine and how to go about preparing interim and final submissions in family law matters. So just before I hand over, I'll let you know that today's webinar is being recorded and we'll have the recording available to download later this afternoon. The PowerPoints have been emailed out this morning and also are located on the handout section of the GoToWebinar control panel for you to grab if you haven't seen the email. And you can ask questions. Again, we'll do that as we usually do at the end of the session, but you can feel free to type questions throughout today's presentation, and I'll read those out for Claire to respond to at the end of the session. So without further ado, I'll hand over now to Claire. Thank you, Claire. Take it away.
Thank you. Good morning, everybody, wherever you happen to be in Australia this fine morning. I was asked to present this seminar following on from one that we did in person at the conference earlier in the year. For those of you who were in attendance at that particular conference and saw the paper, we're going through much of the same material but without the practical examples. For those of you who weren't part of it, hopefully we'll be able to provide you with some information that will assist you assist you in assisting your clients moving forward. When I was asked to prepare the paper originally, I was told that there were some participants who may assist clients in preparing themselves, and there may be some that would actually be preparing the submissions or the cross-examination to appear for those particular clients. So the information is relevant irrespective of what particular role you're performing in relation to the matter. When I presented the paper at the conference, Matt Taylor assisted me in the presentation and we did some practical examples. So I wanted to thank him for his input also in terms of the presentation today. So where do we start? First of all, we should always start with what are the issues in dispute. What are essentially the findings of fact that you or your client want the court to make? So for example, if your client's making various allegations, and we've all seen lots of material that contains, allegations about things that might have happened 20 years ago, are they really relevant, is my question, to the issues that the court has to determine? And that's a really important exercise to go through with clients, because often with family law matters, there's a lot of water under the bridge before we get to where we are today. And it's about helping the client sort through what is actually relevant to what the court has to determine now. So for example, some people get fixated on where money may have been spent over a course of a 20-year relationship, and often the money's been spent on, various everyday living expenses and the like, and the court's not necessarily going to go through a forensic exercise of working out where monies went out of the bank account over that extended period of time. So part of our role is also trying to get the client to focus on what those key issues are that the court needs to look at. The other thing to really bear in mind is trying to get clients not to speculate about things. So one of the things we need to look at is there really evidence to support, for example, an allegation of abuse? So, for example, with parenting matters, you might have young active children or children with disabilities that perhaps are prone to, falling over, knocking into things and causing bruisings. For example, you might have kids who are active kids who ride bicycles and come off bikes at different times and things like that. Part of our role is also about getting the client to really think about, is there perhaps an innocent explanation for what might have occurred? Have they asked the other side about what innocent explanation or what explanation they had for what's occurred? And it's really about trying to get the client to focus on, are there other explanations for these things, rather than just speculating that perhaps it might be as a result of the other party. Also, the client really needs to think about what is it that they want the court to do. So what are the orders that the client is seeking in relation to the matter? Consideration needs to be given to, can the court actually do that? So what's the court's power to make the orders that are being sought by the client? So we often see at the last minute someone trying to seek, for example, child support orders as part of parenting orders. And unless you fit within the very clear section, the court's not going to have the power, in essence, to make the orders that are sought by the client. The other thing to really think about is, why should the court do what it is that the client wants to do, and what evidence is there that supports the orders that the client is seeking or asking for in relation to those matters. Now, some of that comes back to obviously what's in the material itself, there may be an opportunity, if you're helping a client, even if it's a fair way down the track, to assist them in perhaps preparing some further material that they can seek leave from the court to rely upon, that actually deals with some of these issues if there are significant gaps in the evidence. But one of the things they need to think about is what actually is admissible in terms of the court. So is it relevant? Irrelevant material is never going to be admissible. And I've set out there for you the sections of the Evidence Act that you can refer the clients to. And what we've got to look at too is there a logical connection between the evidence and a fact in issue? Because the court's not going to be interested in hearing about whether or not somebody made breakfast for somebody 20 years ago and that type of thing. It's not really necessary in terms of determining the facts that the court has to look at now. And obviously, if it's not, then don't include it. Now, some people try to fall into the trap of thinking that in a parenting matter that Section 69ZT, effectively the rules of evidence don't apply. It's only in relation to certain rules of evidence that don't apply. And there are some rules that do apply, including the section that relates to asking improper questions. And we're going to come back to that in terms of the context of cross-examination itself. But the other thing to bear in mind that the court can, even though the rules may not apply, the court can place whatever weight that they think is fit to the evidence that's admitted. So obviously the best evidence is still the best evidence. So if the client can get an affidavit from the neighbour who saw such and such happen that's relevant to the issues the court has to determine, then it's best that that affidavit come from that person, rather than your client saying, oh, they told me this or they told me that, etc. The other thing to think about is the court may still apply the rules of evidence to an issue in the proceedings if they're satisfied that the circumstances are exceptional, and they have to take into account the importance of the evidence in the proceedings and the nature of the subject matter, the probative value of the evidence, and their power to either adjourn the hearing or to make another order or direction in relation to the evidence. Now, this is relevant because, particularly in cases where there are allegations of sexual abuse or physical abuse, the court may be persuaded in certain cases to strictly apply the rules of evidence. They may also, though, obviously, and you'd be aware in terms of the Briginshaw test, that there is going to be effectively a requirement that the court is required to take into account, obviously, the gravity of what's being alleged when considering the evidence in relation to the matter. So it is really important for clients to understand that they can't just make statements willy-nilly in terms of matters, that the rules of evidence may still be applied in relation to particular matters. The court still, as I said, has a discretion to exclude evidence, and they've got to consider the probative value versus the prejudicial value of the material. And we've seen some applications being made in relation to, for example, recordings, where there might be an objection to recordings being produced, and there might be some suggestion that the prejudicial value of the material might be more than the probative value of it. So clients should also be alive to those issues as well. And the court obviously still has the discretion to limit the use of evidence and to exclude improperly or illegally obtained evidence. It always fascinates me how people think that recordings are, the winning part of the evidence. I can tell you that in my experience, on very few occasions, I probably count on one hand, where recordings have actually helped the client who has made them rather than hindered them. More often than not, they are poorly viewed and can come back to bite the clients in terms of that. So it's good to obviously warn clients about that as well. Now, in terms of preparing to cross-examination, preparation is obviously the key. One of the things that people often don't think about is what is the actual case theory. So what's the story that the client intends to present and ultimately prove? Now, it's important for clients to focus on that because often there's just so much information rather than focusing on really what's the key issue, what are the key facts that we're trying to run in terms of this case, and what is it that we're really saying to the judge in relation to the matter. So you need to also then work out what's actually in dispute. So sometimes parties might be actually saying quite similar things, but in different ways. So it's important to actually sit down and consider what actually is in dispute in terms of the matter and try and focus on those issues, and if possible limit it as much as possible the issues that the court actually has to determine in relation to a matter. And obviously if the parties do agree on something, there's no need to cross-examine about it, so that limits your cross-examination as well. And I'm going to keep coming back to thinking about submissions that the client wants to make at the end of the case, because it's really critical to think about it almost in reverse order. So because obviously you've got to make sure that there is evidence before the court that is going to support the orders that ultimately your client is seeking. And one way to check back to make sure you've got either the evidence before the court in terms of affidavits, but also in terms of what you need to cross-examine about, is relevant to go back to those submissions that you're going to make at the end. So why do we cross-examine? Essentially, we don't cross-examine just for the sake of cross-examining. We seem to find with litigants in person that they seem to fall into one of two categories. Either they don't want to ask any questions at all or have very few questions, or they have such extensive lists of questions that they want to ask of particular witnesses. Obviously, you don't have to ask questions about absolutely everything. It must have a purpose in terms of that. And as I said before, you know, we don't need to cross-examine about issues that the court really doesn't have to make a decision about. And we need to keep in mind the aim of cross-examination, which is to obtain evidence favourable to our client, to weaken the evidence that's been given against our client if we can, and to weaken or destroy the value of the evidence by attacking the credibility of the witness. Now, the last one is one that's you've got to be somewhat careful about in terms of that. There are ways and means of doing it. When I'm talking about attacking the credibility, I'm not necessarily talking about coming in and saying that they've misrepresented the truth or something like that, but it's more about using the evidence that is available to them to enable the court to make a finding that they prefer your client's evidence or the evidence of another witness over that other party's evidence. The court's usually reluctant to make findings regarding credibility if they can go about it in another way. And that's something that I think clients need to be aware of, that a lot of people think that they're going to be vindicated by having a trial and the judge is going to find that they've been completely reasonable and they've told the truth and the other party's a liar and all the rest of it. But we don't often see findings being made about the credibility of people unless they're absolutely necessary in terms of determining the overall matter. So each of you would be familiar with the rule in Browne and Dunn. And people, litigants in person often know about it because they hear people saying, I put to you this and I put to you that, etc. I'm going to say you don't have to use those specific words, but it's important for the clients to actually understand what the rule is all about, which is really, there are two aspects to it. It's to put in issue that which is not accepted by a client, and to put in issue that will be contradicted in terms of the submissions that will be made at the end of the trial. Sorry, I've just lost my slide. The duty is really just to put as much of your client's case as applies to that witness, so you don't have to put every allegation to every witness. It's only in relation to the areas that relate to that particular witness themselves. And as I said before, you don't have to say, I put it to you. It's about putting the concepts to them. And also, as I said, you don't have to put every allegation. So if a party blatantly denies, you know, ever committing, for example, domestic violence in any way, shape or form, then you don't necessarily have to put every single incident to that particular person if it's a flat out denial when you start going through the allegations with them. So what do we cross-examine about? As I said before, start at the end, look at your submissions, consider what are the things that the court has to consider and what submissions are you going to make on each of those facts. What orders are you seeking? Is there any evidence on those points or matters before the court? If not, you might be able to try and elicit some evidence about those matters in cross-examination. And you need to consider what evidence needs to come out or be highlighted or refuted in order to allow you to make the submissions that you intend to make at the end of the hearing. So the way I normally go about it is think about what the key issues in the case are. What are the points that we need to make in relation to that particular topic area, and then either write out questions or those topic areas that you want to cover and the key point that you want to achieve by cross-examining on that topic. I always include in my notes references to where the relevant evidence is, because sometimes you might, for example, be saying to a witness, look, you say in your affidavit, X, Y, Z, and then there might be another question that goes on from there. So, for example, I use a little system where if it's a father's trial affidavit, I just put an F and the paragraph numbers in the square brackets, or if it's a family report reference, something like that in my note, because sometimes if the witness says, oh, I don't remember saying that, for example, or the judge is trying to follow what you're putting to the particular witness, then it's helpful to have those references handy so that you can either refer the witness to it or refer the judge to it if you're being asked to do so. Alternatively, you might, for example, say you might be cross-examining the witness about a particular incident that involved the police, and there's a reference in the subpoena tender bundle. And so you might say, for example, for Your Honour's benefit, I'm taking the witness through the document that appears at page blah of the subpoena tender bundle. And that way, it also assists you when you're making your submissions or preparing in terms of any oral evidence that's occurred during the course of the trial to add to your submissions, finding those references and your notes of what the evidence was in relation to those particular things. So in what order do you ask the questions? I always think that you deal with the areas where the witness is likely to give helpful evidence first. For example, if there are some concessions that you think they might make for you, you can start off all very pleasantly and try and get those concessions that you can out of them to start with. Witnesses are generally less likely to want to help you or give you what you want after you've had a crack at their credit or put a series of propositions to them that they disagree with. So get anything that you need to get that might be helpful to your client out early if you can, whilst they're still hopefully in a good frame of mind. I think, generally speaking, you've got to bear in mind who the listener is in terms of the cross-examination, and that's the judge. Usually going through a chronological sequence under topics or subjects is helpful to them. And it's often useful to do some signposting in terms of moving on to a new topic or something like that, because a number of the judges are quite proactive in terms of wanting to ask questions themselves. So if they might have some, there might be something that arises for them in terms of the question. Some of them will ask the question straight away. Some will wait till you finish cross-examining on that topic, and then if the witness hasn't answered whatever it is that they are concerned about during the course of their evidence, then they will want to ask the question at that point in time. What I would say to you is that let clients know that the judge might do that. It's a good thing rather than a bad thing usually, although sometimes the judges ask the question that you don't want to ask and you're kind of stuck with whatever the answer is. But generally speaking, it will also show for the client that the judge is interested in this particular topic or interested in knowing something about that particular topic, which is a flag for you in terms of some things that you might also need to address in terms of submissions later on. But I think it's about making sure that it's easy for whoever's listening to it to follow what you're trying to do in terms of the cross-examination itself. As I said before, as best you can, complete each subject before you move on to the next. So the topic may be in several different documents. It's really for the client to assemble the material. So it might be that the person's made statements about this particular event in, their first affidavit, their second affidavit, and also gave a statement to police and or Department of Child Safety, for example. It's really for the client to assemble all of that stuff. And if there are inconsistencies, for example, in terms of that material, then obviously they've got to be organised about that so they can fairly put to the client to the other party what those inconsistencies are. And as I said before, make a note of where it's actually dealt with so that when they're on their feet, they're not getting flustered when they can't find the document to refer the judge to if the judge is asking, so that they can follow what's going on as well. So how do we actually go about cross-examining? I know this sounds really simple, but it's about asking questions, but it's about one simple question at a time. People often make statements rather than actually ask questions. That's obviously one of the things that people object to and say, well, is there a question in that? Or, you know, I don't understand what the question is because it's just been a statement. Sometimes litigants in person are also prone to making speeches or trying to argue with the witness at the outset, and it's not obviously an opportunity to do that either. In terms of cross-examination, we generally ask leading questions. So the easiest way I find to explain that to clients is that you're looking at questions that invite a yes or no answer. And the reason that you're trying to do that is to stop the witness, in essence, wanting to repeat what's their evidence in chief, essentially. And it's also to keep control of the evidence as it falls out. So it's those short, sharp questions that usually invite a yes-no type of answer are really good. And it's about one proposition or one point at a time, as far as that goes. There needs to be, obviously, some sort of internal logic to your questions. So you've got to know where you're going with them. So it's about building, for example, on that topic. So it might be one little piece that are the building blocks until you get to your final note. We often talk about trying to close the gates for a witness so that there's nowhere for them to run other than to agree with what you want to say. So that's ruling out all of the other possibilities and leaving only the option that you want them to agree with. So it's good to think about closing their gates as well. Obviously, cross-examination is not about expressing personal views and not about attacking the witness or engaging the witness in argument. Now, this is a challenge for people, particularly when they're self-represented, because in family law matters, obviously, as I said before, there's a lot of water under the bridge before you get to where you get to. People generally know how to push each other's buttons, and the client needs to really think about how they're going to manage that in terms of the process. It's not for the witness to ask questions of them, and they shouldn't engage in that if they do. Hopefully the judge will pull them up fairly quickly, but the client just needs to be aware of that and just not let themselves get caught up in having an argument with the witness as far as that goes. And as I said, don't respond to questions from the witness. The other thing not to do is to remind the witness that they're on oath or of the penalty for not telling the truth. Some of the judges do that. For example, Judge Vasta up here, for example, after witnesses are sworn in, he usually gives them a bit of a lecture about the seriousness of the oath or the affirmation and penalties involved in that. So it's a matter for the judge to remind people about that, not for the cross-examiner. One of the things that is important when you are cross-examining, though, is to be flexible. So clients need to be prepared to go off script. And what I mean by that is they need to listen to the answer the witness gives. And if there's something of significance in that evidence, they should write it down word for word because they might want to ask some other questions about that, i.e. to test what they've just said, or they might want to make a submission about it at the other end. So if clients are appearing in person, sometimes it's hard to cross-examine at the same time as writing notes. So they might want to have a friend come with them to court to write notes of the evidence for them so that they've got that to refer back to when the submission's made. But it's important for that person to note the question that's being answered and the answer given so that you can be quoted back word for word if they can do. Now, the importance of that is that if people aren't listening to the answer that's been given, they might completely miss that they've just been handed the gold nugget, so to speak. So, you know, there might have just been an answer that sort of was an admission that they completely missed, and just, if they're so focused on answering or asking, sorry, the next question that they've got on their list. So it's important for them to listen to those answers, and then if they need to, go off and explore that topic. But their notes are useful for them to come back to in terms of knowing then what else they need to cover in that particular topic area. So, for example, I prepared some notes either in terms of the topic areas or questions If the witness keeps wanting to say something about something, I might go off and deal with that topic, but then I'll come back to the original topic. And my notes obviously help me to make sure that I don't miss anything in that process. So in terms of cross-examination, there's a great book on advocacy that's written by Glissan, and he had some deadly sins that are outlined in that particular book in terms of cross-examination itself. So we often say, don't ask a question that you don't know the answer to before asking the question. I mean, obviously, you know that some things are going to be denied, but you still have to go through the process of cross-examining about those issues. But if it's something that you really don't know, then it's kind of dangerous to ask a question that you're not sure what's going to happen in terms of that. Similarly, going fishing is a bad idea because you're not quite sure what the person's going to say in answer to the question, so you should avoid doing that generally. One of the things too, as I said to you before, we often use leading questions for cross-examination purposes, and one of the things that people often do is ask open questions or invite explanations. And that essentially is what we're calling dropping your guard, because it basically allows the witness to repeat their evidence in chief or give some other evidence. Now, there are times when I will do that as counsel, and it's usually because if, for example, the evidence of the party so far has been interesting, and it may be that the add-ons that they can't resist adding are going to be helpful to my client's case, in which case I might give them a little more leeway than I might otherwise. But if somebody's going off on their own little tangent and it's not responsive to the question, then you can pull them up and say, no, stop, just answer my question, or come back to my question, please, and repeat what the question is. But sometimes, as I say, the person's rabbiting on is actually helpful to your client's case, and you'll let them go. The other thing to bear in mind is not to try to improve a good answer. So if the person has actually given you some gold in terms of that answer, move on. Don't say, thank you for that, and move on. Just literally move on, so that, because obviously if the witness suddenly realises that you might have said something that's helpful, they may then seek to try and retract that evidence. So it's best to keep your poker face on and keep moving through the questions, because oftentimes they don't realise that they've given you what you really need. I've already mentioned not arguing with the witness. And the other thing is that question too far. So often you need to think about, how far do I need to go with the witness? Because it may be that the conclusion is actually something that you can leave for submissions rather than having to put that to the witness. As long as you've got the facts or got the evidence that you need from this particular witness to enable you to make the submission, then that's far enough. And I know that's hard sometimes to determine when you're on your feet, but it's something to bear in mind in terms of leaving that save that final point for submissions themselves. Now, one of the things that clients need to be aware of are objections to evidence. So even though parties are self-represented, if there is, for example, an independent children's lawyer involved or otherwise, then there may be a need for objections to evidence, or there might be objections obviously being made by the lawyer for the other party in terms of a question that the client is asking of the witness. So it's good for them to be aware of objections. So some of them, leading questions are obviously relevant in terms of if evidence in chief is being led. I know that's a contradiction in terms almost, in the sense that we talk about leading evidence in terms of cross-examination, but actually when you lead evidence in chief, you can't actually ask leading questions. So it's a bit of an anomaly there, but if the client's leading evidence, then obviously they can't ask leading questions, and similarly in re-examination, they can't ask leading questions. In terms of cross-examination though, and more generally, if the question is too non-specific or too general, then obviously there could be an objection to that, and one might question the weight, if any, that would be placed on that evidence anyway. Questions can often be confusing, misleading, or vague. Now, sometimes we'll just let some of those go through to the keeper, so to speak, and let the client sort of say, look, I don't understand what you're asking me, or seeking to clarify what it is that's being asked. But there may be objections made if it's too confusing, misleading, or vague. Similarly, if it's a compound question, so for example, if it's got several parts to the question. Again, one might question what weight might be placed on that because you're never quite sure which part the client has asked. But there can be an objection made and said, well, can it be broken down into parts, please? If a question's argumentative, obviously there can be an objection made to that. Or if the question's calling for a conclusion, there can be an objection also made to that. An unfounded attack on credit, there can be objections made to that. And it's not helpful to clients' cases either if they're asking questions of that nature. There can also be objections as to content. So if they're asking something that's completely irrelevant, for example, whether or not they had a relationship with, I don't know, someone 25 years ago is going to be completely irrelevant, generally speaking, to issues the court might have to determine now. This is a big one. People often assume facts that are not in evidence, or they might have misstated or misquoted the witness, and that's where it's important, again, for clients to be across what is actually before the court. So clients oftentimes have a lot of information that's in their head. They have a lot of information that might be in other documents that aren't before the court, or might be in subpoena material but haven't been tendered. So it's important to make sure that anything that's being asked of is actually before the court in terms of the evidence itself. And similarly, it's important to get the witness's evidence correct if you're asking them some further questions about that particular evidence. There can also be an objection if something's purely speculative. Again, it's a question of how much weight the court would place on any answer to that anyway. So sometimes the questions are allowed, but you know, question of weight as far as that goes. There can also be objections taken in relation to privilege. Now, this is an important area. I've had this issue arise recently, where people might choose to rely upon legal advice as a reason why they have or haven't done certain things. It's important that clients be aware that if they give answers that essentially give information regarding legal advice they might have received, that they may waive privilege in relation to those matters, and that there may then be you know, subpoenas issued to solicitors or otherwise in relation to those matters. So it is important for clients to be aware of issues related to privilege. Hearsay is obviously an obvious one. Unresponsive or volunteered answers. So that was what I was talking about before in terms of where a witness keeps, you know, going off tangent or talking about stuff that's not relevant to the question that was being asked. It is okay for clients to say, no, stop, can you please just focus on my question? My question was X, and see, but again, they need to be careful to make sure it's a closed question so it doesn't give the opportunity for them to go off on these tangents if they want to. Prejudice is another basis for objections, and people who are not experts giving opinion evidence. If a client wants to object to a question that's being asked, then they can do so, but it needs to fall into one of those categories that I've already mentioned. They should object immediately, stand up and say, I object. And so it's clear that that there is an objection to the particular question. Because once the question's been answered, it's too late. Essentially, the horse is bolted in that regard. The other thing that clients need to understand is that there is a difference between an objection to the question and an objection to the evidence that's been given as a result. So oftentimes people stand up and object because they're not happy with the evidence that's been given as a result of a question that may have been asked as opposed to the actual question itself. Now, re-examination. I rarely re-examine people. I'll only do it if I know exactly what my client's going to say in response to certain questions, and it's usually very brief. But essentially it's to allow a witness to put in context or to complete or to explain answers that they've given during cross-examination. It might usually be something like they might have been cross-examined by someone and they've said that they sent an email to somebody on a certain date, and you've got a copy of that email and you can tender that through the re-examination process if it's going to be helpful. It's obviously not to open up a new line of examination in chief or matters that don't properly arise from cross-examination, and a client can object if the other side's then trying to get new evidence in through that process. But you've got to bear in mind you can't lead the witness in terms of re-examination. So I was going to then move on to preparing interim submissions. So I don't know if there's, well, perhaps we can deal with any questions at the end. more generally. So in terms of preparing for interim submissions, the court's obviously got to follow the legislative pathway that's set out in Good and Good, and I've set out there Banks, which is one of the more recent decisions in relation to the pathways, but essentially that's the process that the court needs to go through in terms of determining interim matters. So first of all, they've got to consider what are the competing proposals, what are the issues in dispute at the interim hearing. Court's got to identify agreed or uncontested facts. They need to address the Section 60cc factors that are relevant, and they need to consider the issues around equal shared parental responsibility and the presumption in Section 61DA. And obviously once an order for equal shared parental responsibility is made, then the court's obliged to consider equal time and in the alternative substantial and significant time if of course the court's satisfied that it's in the child's best interest and it's reasonably practicable. And it's important for the clerks to be aware of those particular sections and what the court has to consider in determining whether or not something is reasonably practicable. In terms of my submissions, I actually use those headings normally if I'm doing a written submission on an interim matter, and then go through each of those things and do a summary at the end. Now, obviously, if a client's doing it orally, then they don't necessarily have to say this is, using those particular headings, but it's still helpful for them in terms of preparing their material to think about each of those things. Other things for them to consider is look at what the other party says in their material, and is there anything that you can use to support your case. This is really critical because at an interim stage, the court doesn't have the opportunity to make findings of fact in relation to those matters. And sometimes the best evidence comes from the other side's material because they might make some concessions about certain things that you can then use to support your case. The other thing to really look at is there any independent evidence available that can be used? And if there is, then use it. So that might come through subpoenaed documents or, for example, a Section 11F report or a family report in relation to a matter. And as I said before, think about the format and presentation of it. So again, what clients need to bear in mind is that you're in a busy duty list normally. Some of the judges will list matters for discrete interim hearing dates and might get a couple of hours in the morning or afternoon to do that. But if you're in an interim duty list, it's really important to explain briefly what it's about, what is actually in dispute, and what the evidence that's relevant to those issues in dispute are. In terms of actually preparing for interim hearings, I think it's always, useful for the judge, for the client, to be able to hand up to the judge a minute of the orders that they're seeking, because the judge then has that in front of them and they can either tick off or see where the areas of disagreement might be, and as they're going through the submissions, they might be able to then say, well, I will make orders 1, 2 and 3 of your client's draft in terms of those matters as well. Obviously, if the client, and I should say the other thing is clients can obviously access the duty lawyer services on the day of court if they need some assistance, but for them to get the best benefit out of that, it's good if they can do some preparation in terms of their matters in advance so that they know really what the issues are and what specifically they need help with on the day. So what's different then in terms of preparing for final submissions? The objects really in terms of final submissions are to summarise and collate the evidence which relates to your client's case, and to argue the evidence in relation to each issue that the court has to determine. So essentially it's helping the court to identify the evidence that supports the findings that your client wants the court to make, and that then supports the orders that your client is seeking. There's also the point of submissions is to damage the other party's case sought to be made and address any of those issues in your case head on. So it's important, for example, if you know that there's this argument that's going to be raised against you, to address that as best you can and give the court a way to not find against you in relation to that particular issue, so to come up with another option. And really submissions more generally are to give the judge a pathway to find the way that you want his or her honour to do so. In terms of final submissions, it depends on which particular judge you have as to their preference. For example, in child protection matters, we have one of the Children's Court magistrates who always asks for written submissions in relation to those matters. Some of the judges in the family and federal circuit courts in Brisbane certainly prefer written, some don't. Some prefer oral submissions. Even if you do a written outline, still the client needs to be prepared to make some oral submissions as well. And if they are, though, doing oral submissions and they've done a written outline, they shouldn't just stand there and read out what they've written. And don't just rely on your best points being in that written outline. The purpose of making the oral submissions is really to emphasise certain points and engage the judge in terms of those discussions. It's also for you to get an idea from the judge about some of the things that are troubling them, and you can then use that opportunity in oral submissions to assist them in finding that way through to what it is that you want them to order. So in terms of oral submissions, again, you need to have a structure, and if the judge is asking the client about something or asking you about something, then they need to address their questions. It's really an opportunity for them to try and persuade the judge about that particular point. So one of the family court judges here will often ask questions during the course of submissions, and has expressed disappointment at times when people have just then said, oh, you know, I withdraw that, Your Honour, and they move on to some other point rather than engaging in the discussion. Judges sometimes ask questions because they really want to understand what it is that you're saying, and they want you to help them to find whatever it is in terms of the evidence that they can use to find the way that you want them to. So it's a really good opportunity for clients to actually engage in that dialogue with the judge. However, they should need to read the cues from the judge. So if the judge is telling them to move on, then it's best that they do so. And if they're telling you that they're not being persuaded, you can have a go at trying to change their mind in relation to that issue, or in essence decide to move on, because obviously if you're not having any success in that regard, you might choose to move on to one of your other points that you think is actually a better one. In terms of written submissions, I generally try to think of it as being like a template from which the judge can write their reasons for judgment. So obviously it sets out again in terms of various headings what the evidence is in relation to particular issues. Obviously from a reading perspective, it's important to have numbered paragraphs. Headings are useful to try and find things, and page numbers, I know that seems really simple, but you'd be surprised how many times we see documents without page numbers on them. And it's important also to assist the judge in terms of footnoting those submissions or including in brackets references to where the actual material is. So if you're saying that you know, the respondent said in their affidavit X, Y, Z, it's important obviously to save the judge having to read the whole document to find the paragraph that they're referring to, but they actually include the reference in terms of that. And the same thing with exhibit numbers. So it's important also to tell clients when you're going through a trial process that they keep a separate list of documents that are being tendered and the exhibit numbers, so that in the submissions they can easily find what the exhibit number was for that particular document. If they miss something along the way, they can ask the judge's associate at the end of the day if they can just check the exhibit numbers so that they make sure that they've got them accurate as well. In terms of the format for final submissions, this is just an example of the way I normally do it. So I normally do an introduction, which is effectively a bit of a what it is that we're seeking and a summary of why we say that should happen. I should say actually just in relation to that, in some matters I've had recently where I've been for the independent children's lawyer, I've often at the outset, as the opening paragraph, talked a little bit about the child, who they are and what their particular needs are. And then I've had some where there's been high conflict cases and just done a little paragraph around what it is that we're trying to achieve through the orders that are being sought by the independent children's lawyer. But it's helpful to give an introduction, particularly because sometimes with written submissions, if they're being filed after the trial date, the judge may have dealt with, I don't know how many other matters in between, and it kind of is designed to bring them back into, oh yes, that's right, this is this case about X, Y, Z. In terms of setting out a summary of the legal principles, the court doesn't necessarily expect that so much from litigants in person. From a lawyer's perspective, there's obviously usually some key cases that might be referred to. The judges don't necessarily expect us to go over the law unless there's something particularly unique in terms of this particular matter, or if, for example, there's something that's exactly on point that you want to draw the judge's attention to. The clients really need to work out how they're going to present the information as to whether it's under topics or relevant sections. I do a mix, so it depends on the particular matter. It might be that there are certain key issues in relation to the matter that the court's going to need to make findings about. So, for example, if there are family violence issues, there might have been particular incidences that you're inviting the court to make particular findings about, and you might set out an overall heading of family and domestic violence, and then within that have some subheadings dealing with particular incidences that you want findings in relation to. The other option is if it's a parenting matter, you might just deal with it under topic headings that are similar to the Section 60CC factors, or deal with parental responsibility and these particular issues. It just depends on how the evidence has fallen and what really the key issues are. The client just needs to set out the facts in short form. They don't need to necessarily quote wads of information from the affidavit material or from the family report. They can give a summary version and put a footnote in to identify where the source of that information has come from. And they only need to refer to the evidence that's relevant to the court's determination. So even though the other side may have made a whole lot of allegations that your client may or may not have responded to in the material, they don't need to address each and every one of those things in the overall submissions. It's really about coming back to that focus of what does the court really need to determine to make the orders that are being sought by the parties, and bringing it back to that. If the client's not necessarily comfortable with that, they can say, look, Your Honour, there's a whole lot of allegations that were made against me about these matters. I say they're not relevant to the issues the court's got to determine, and hadn't intended to address, Your Honour, in relation to those matters. If, however, Your Honour wants me to go through them, then I will do so. And usually the judge will say, no, it's okay. I don't need you to address those matters. In terms of the written submissions, though, I normally conclude the written submission with a short summary pointing out the reasons why the relief ought to be granted and the orders sought as made, orders made as sought by the client. I should say that often at the end, before I do that summary paragraph, if there are particular orders that are sought, for example, overseas travel orders, I would set out specifically the evidence that's before the court in relation to those issues. And I should say overseas travel orders are one of the things that are often dealt with poorly in terms of people's material. So people just obviously find a precedent somewhere that says that they want to go overseas, etc. If there is a dispute about that, often the court will wait until somebody actually has a fixed plan. So if the client has some intention to travel or has a reason why they might want to travel, then it's important to make sure that that's in the evidence or comes out during the course of the trial, and they should specifically address those particular issues in the submissions. Similarly, for example, schooling is another one that we often see poorly dealt with. People say they want the kids to go to one particular school and someone will say the other one. Oftentimes there's no evidence before the court about why that particular school would be best for the child. Often they might have just said, oh, I've made an inquiry and we can get them in there, but there's no evidence, for example, at private schools in relation to fees, what the proposal is in terms of payment of those fees, all of those types of things. And often there's very limited evidence as to why one school might be better for the particular child's needs. So, and it's important to have some more information other than just what's on the internet about the school or the school's ranking or otherwise. But again, if there are particular orders sought about those particular things, then that needs to be addressed in terms of the submissions as to why the court would make the orders as sought by the client. So just on a final note, go back to the issues in dispute or the order sought and make sure, as I was just saying, that they're addressed in each of the in terms of submissions. It's important for clients to know that they shouldn't interrupt the other person's submissions. And it's also important for the client to understand the order in which submissions will be made. I should just touch on that. If the client is the applicant in the proceedings, then normally they would make their submissions last. Having said that, if the other party is represented and the client's unrepresented, oftentimes the judges will ask the represented party to go first. Not always the case, but sometimes they will. So it's unsurprising to me if I'm representing a party in proceedings and the other party's in person, if the judge says to me, you know, make your submissions first, and then they'll usually give me then an opportunity to respond to anything that arises from the other party's submissions. If there's a case involving an independent children's lawyer, then normally the independent children's lawyer would make their submissions first, then the respondent, then the applicant. But what's important is that litigants in person need to understand that they shouldn't interrupt the other party's submissions, even if they object to what is being submitted. There will be an opportunity for them to speak, and they should make a note of it and deal with it at the end of the other person's submissions. They shouldn't also use inflammatory language or make appeals to the personal interests of the court. That doesn't particularly help them in terms of that. And they also need to make sure that they actually answer the judge's questions. So some clients try to avoid them because they may not be or feel that they're necessarily helpful to them, but that just annoys the judges, and so they need to have their best go at trying to persuade the judge their way if the judge has a question about something in particular. I've just put up there the Victorian Legal Aid How to Run a Family Law Case guide. I think it's quite a useful guide for clients to have a look at if they are preparing their own cases. There is also obviously now a lot of information available on the Federal Circuit Court and the Family Court websites in relation to preparing matters as well. So that's it from me for today. I'm happy to take any questions if people have any particular questions in relation to any of those topics. I know we've covered a lot of material for today, but hopefully it will be useful in assisting you in working with your clients.
Thank you, Claire. That was fantastic. I'll just remind people that they can ask questions by typing their question into the question box on the GoToWebinar control panel. So you can feel free to do that now. We haven't had any come through just yet, but Claire, I thought that was a fantastic, very practical and helpful presentation with some great suggestions for self-rep litigants to use in practice, and particularly I thought, you know, some good tips to pass on to those clients on what to do and what not to do, including those deadly sins. So hopefully everyone got some value out of today's session. Still no questions coming through, Claire, so perhaps you have covered everything so well that they haven't needed to ask anything. I'll just give people another 1 or 2 minutes just in case they're madly typing away. So I'll just hang about for a couple more moments.
It's all right. I don't know if it's a good thing or a bad thing. As I was saying, it's nice sometimes to be engaging with the judge so that you know what that they're hearing what you're saying and you're able to address their issues.
Yes, okay. So a couple have come through now, Claire, as suspected. Mm-hmm. So Jacqueline has asked, what can self-reps do if a judge shuts them down before they can finish what they have to say?
Well, it depends on the particular issue that's being addressed. So if the judge is shutting them down in a way in terms of saying, look, I understand what you're saying in relation to that particular topic and what you've said in relation to it, and then are asking them to move on, then they should acknowledge that and listen to it. Sometimes we find litigants in person, they need to really listen to what the judge is actually saying to them, because sometimes they're reading that as being cut off, but it might be that they've said the same thing about 4 times and the judge has got the point and wants them to move on. If though it's something that they haven't yet addressed, then you know, they are entitled to say, Your Honour, I just want to finish this particular topic, and I'll do that as quickly as I can, and then move on. But it is difficult. They need to really think about what it is that the judge is saying in terms of trying to shut them down. Hopefully that's answered that question.
Great, thank you. So I've got another question here. So do you have any suggestions for how to deal with litigants in person who won't accept advice? Potentially comment in the sector.
Sorry, I shouldn't laugh. When I've got, litigants in person who don't accept advice are a challenge. I mean, ultimately people are entitled to have a trial, and a judge will make a determination about those issues. Sometimes clients, well, there's a couple of options. You can try and send them off to the duty lawyer. Sometimes judges will give people intimations about or give preliminary views in relation to matters, obviously saying or acknowledging that that they haven't heard all of the evidence and all the rest of it, but sometimes it's helpful for litigants in person who don't seem to be wanting to accept advice to hear from the judge what some of those particular issues might be or challenges that they might face in terms of making the case that they want to. And so you can sometimes invite a judge to give some preliminary views or give some intimations about particular issues. Sometimes we do that at the end of the evidence because then the judge might stand down to enable people to have some further negotiations about matters, having now heard the evidence about particular issues. The other thing to bear in mind, and it depends on which judge you're before, but what I've done in some cases is if you know that there is one particular issue that's the block, and that particular litigant in person can't move past that particular issue. So it might be, for example, an unacceptable risk issue, or it might be an issue of contributions, for example. The Federal Circuit Court does have the power to list matters for a discrete hearing on a particular issue. And I've done that in some cases where I've asked the court to list it just for that particular issue because the rest of it all seems to be agreed. And if we can move past that, then perhaps, you know, you can sort the whole thing out. So that might be another option for them to seek to it be listed to deal with that particular issue and then hopefully be able to resolve the matter from there.
Okay, thank you. Laura's asked whether self-repped people are allowed to take notes during their own cross-examination so they can essentially re-examine themselves, as it can be hard to remember everything they were questioned about after hours of cross-examination.
It depends on the judge. I say yes, and some of the judges will invite the litigants in person to take a notepad with them so they can make that note. The judges that I've had where they've not allowed them to do that have generally kept a bit of their own list where they've then at the end of the cross-examination said to the separate representative, I think you were wanting to say something, you know, more about this. Was there anything more you wanted to add, or there was this particular topic that you've raised something, do you want to say anything more about that? So I think it's a yes, they need to ask if they can take a notepad and pen with them so they can jot notes down if they need to. And if they're not going to, then there needs to be some discussion with the judge about how that might be dealt with otherwise so they remember what it is they need to deal with in re-examination.
Okay, hopefully that's helpful, Laura. Jacqueline's just asked, I think it's maybe a second part to her previous question.
Yep.
So, Jacqueline, I hope I explained this all right. It's come through in two separate bits. So she said, for example, at the start, the client wants to introduce a Mackenzie friend and then allowed to get it out. The client is vulnerable. Do you have anything to say to that, Claire? So
they're not allowed to get out that they want the Mackenzie friend appointed?
I think that might be where she's heading with this one. Sorry, she hasn't. I've asked.
Okay. No, that's okay. In terms of, well, there's parts of it. There needs to be some evidence before the court that's usually by way of affidavit in terms of what the client's particular vulnerabilities are so that they can rely upon that. I think there's a difference between, and you need to be conscious about who it is that the client's seeking be the Mackenzie friend, because sometimes the person that they're seeking to have involved as the Mackenzie friend is almost part of the dispute or is not going to assist in terms of the dispute. So it really depends on you know, who that person is and what evidence there is of the person's need to have that support in the courtroom. So the other option is to actually make a formal application in a case for them to have someone there if the judge is not giving them airtime in relation to that, in relation to perhaps interim proceedings. But the other option is for them to seek to stand down to get some assistance from the duty lawyer so that they can get some advice about that particular issue if they need to do so, in the hope that then they might be able to either get some assistance from the duty lawyer in that particular fact scenario or try and work out a plan as to how to approach it with the judge if they're getting no opportunity to have make that application.
Okay, fantastic. That's all the questions we have received for this session. We're almost perfectly on time, so we might wrap it up there. Thank you again so much, Claire, for your time today in presenting to our group. Hopefully everyone has been madly writing notes and will be able to use some of these really gems of tips in practice. And we'll see you for next time, our next webinar later in the month. Thank you so much, everyone. Have a great weekend.
Thank you.
Thanks, Claire.
Thanks very much.